Hello.
Hello.
Hello, Jonathan. Hello, everybody. Thank you for joining us in a new MiCA Crypto Alliance webinar. Today's webinar is called Defending Decentralization, Why Bitcoin and Similar Assets Should Remain Out of Scope. And I am pleased to be joined by Jonathan Galea, a brilliant legal mind. The rumor is he's got MiCA memorized, so I'm extremely humbled to be in this webinar with him. And we're going to be discussing a bit about MiCA, how to interpret it, which assets are in and out of scope, and why, right? So we're going to be using these questions that I'm going to be introducing in a second as an excuse to explore a bit more and understand a bit more the spirit of MiCA, the legal theory that needs to be applied in interpreting MiCA, and much more. But before we continue, I'd really like to give a welcome to our guest. So, Jonathan, if you'd like to introduce yourself, please, you've got the floor.
Thanks, Juan. Thanks for the humbling introduction and as well for the invitation to this webinar. I'm Jonathan, and I'm counsel at Cahill, part of the digital assets practice called Cahill Next. And now this marks my 12th year in the crypto space, where essentially I've seen the birth of altcoins taking place and the flourishing of the industry, which has experienced magnificent growth. In 2017, I had set up a crypto-focused consultancy firm with its own law firm as well, targeting ICOs back then, DeFi protocols later on, licensed exchanges, and pretty much everything in between, anything else in between. So covered the full gamut of the industry with regulatory and legal advice. And since the Counsel version of MiCA that was published around 3 years ago, I've been avidly following the development of this framework and very much interested in discussing anything relevant to MiCA, but especially today's topic.
So you don't just know, say, MiCA in its current form. You've been through its formation. You know where it's coming from. So your perspective is going to be super valuable. Thank you for being with us. And let me introduce a bit also the MiCA Crypto Alliance for those that don't know us. We're an initiative to create and uphold and assist the industry in upholding best practices in MiCA compliance. We have done a lot of work like supporting players comply with white paper requirements and MiCA sustainability requirements, but also we are trying to just tackle hard questions. And part of the establishing best practices under MiCA is actually understanding what MiCA says to begin with. So a few weeks ago, the MiCA Crypto Alliance, we had a webinar where we hosted a sort of novel view. And this novel view was that Bitcoin is and similar assets needs a MiCA white paper, which is a perspective that typically we don't is not considered to be true. It's not the consensus, right? So there is an exemption in MiCA for assets without an identifiable issuer. Bitcoin is not considered to have an identifiable issuer. Therefore, Bitcoin does not need that sort of white paper. So we should focus, white paper should be focused on other kinds of assets. However, there was an article by a legal scholar, PhD candidate, that published, I believe it was in Oxford Law Review, the argument that, no, wait a second, Bitcoin does need a MiCA white paper. And here's some reasons why. So that view was presented. I'll briefly walk us over it, but I really want to hear John's insights on the matter. So before we do that, maybe we can get a slide on screen where we are going to just dive into it and read a very important recital in MiCA, which is recital 22, right? So this is before the articles of MiCA. And it establishes, for instance, that crypto asset services, if they are provided in a decentralized manner, they are not within the scope of MiCA. And in yellow on screen, we can see that if an asset does not have an identifiable issuer, it should not fall within the scope of Title 2, 3, or 4. Now, here we're very interested in Title 2, which regulates assets that are other than those assets that are e-money tokens or asset reference tokens. So like your average token that is not a stable coin or asset referenced. So this is in yellow what we typically use to say, well, Bitcoin is not within the scope of the regulation because Bitcoin doesn't have an identifiable issuer. However, this view that we were presented with recently would say, well, wait a second, there's a sentence after that saying that the crypto asset service providers providing services in respect of such crypto assets should, however, be covered by this regulation. So that was one of two arguments. We'll get into the other one in a second, saying Bitcoin does need a white paper. It's true that it doesn't need one in itself, but the moment a crypto as a service provider wants to provide services in respect to Bitcoin, then it's covered by this regulation. So that was one of the arguments that was presented. And I want to ask John, is this, are you in agreement with this, or what do you think of that?
So, first and foremost, it's good to point out that the preamble, including all the recitals, are technically not the law itself. Typically, recitals present us with the spirit of the law, the intention of the legislator, and what is normally found in the recitals can typically be found in the very text of the law itself, which are the articles. Now, interestingly enough, the phrase where no identifiable issuer, where a crypto asset does not have an identifiable issuer, it should not fall within the scope of including Title 2. That particular phrase, that particular sentence in the recital does not have an exact, let's say, replication, an exact mirror of the phrasing within Title 2 itself. What we do have under Title 2 are certain exemptions afforded under Article 4 in relation to certain offers to the public. Going back to Recital 22, why do we have that specific sentence? The reason for that is because A, if a crypto asset has no issuer and it is being issued in a pre-programmed way, in a hard-coded way, so to speak, so there is no person responsible for its issuance, it would be very hard to, I would say, bring to heel any person and make them responsible for the respective obligations under MiCA. Secondly, if there is the lack of a legal relationship between the original issuer of that crypto asset and the user of that crypto asset, ultimately, the potential risk, the investor risk, so to speak, for the end user tends to be quite low when compared to other crypto assets with an identifiable issuer and which are potentially allocated a significant portion of that same token. So overall, crypto assets without an identifiable issuer tend to have generally a lower risk profile. And although I'm not in the mind of the legislator, I would venture to think that those are some of the reasons as to why that particular sentence was included in Recital 22.
So these seems to be like reasons why your and also the most common interpretation of it is the most convenient, right? But would you say there is a reason in text, or is it more like are you investigating the spirit of MiCA to answer this question?
So I'm focusing for now just on the recital itself. I'm happy to enter into further discussions once we start discussing the articles themselves.
Okay.
On the other point that you raised, Juan, which is the following sentence where it stated that crypto asset service providers should, however, still remain in scope no matter which crypto asset they're offering their services in relation thereto. Well, this naturally has to be the case because regardless of whether a crypto asset is, let's say, exempted from certain requirements under MiCA, ultimately, if you are a crypto asset service provider and you are providing crypto asset services, it would not make sense to have your crypto asset services regulated in relation to certain crypto assets and not regulated in relation to other crypto assets. Ultimately, crypto asset services should not be commingled with crypto asset issuances or offered to the public or the very act of admission to trading. They are separately regulated. Title 2 covers offers to the public and admission to trading. Title 5 regulates crypto asset service providers. So I don't believe that that additional sentence in Recital 22 should give rise to any confusion or conflation of the two concepts.
All right. So you do agree that crypto asset service providers are nevertheless covered by the regulation. You just don't think that this includes a duty on their side to prepare a white paper for the asset without an identifiable issuer, right? It's not. The sentence survives your interpretation. It's just that you don't believe it's included.
Correct, because the requirements to draft, notify, and publish a white paper are covered under Title 2. They're not covered under Title 5 of MiCA. Incidentally as well, for instance, and perhaps I might be jumping ahead here, but we find further evidence of the applicability of Title 5 to costs, no matter the crypto asset involved, in the suitability assessment, which must be carried out by trading platforms. And there's even the text of the law itself, which states that suitability assessment has to be carried out in relation to all crypto assets, regardless of whether there's an exclusion applicable to such crypto assets or otherwise.
Actually, no, that's not jumping ahead, because that was exactly the next thing I was going to ask. Like, if sustainability data requirements are also like in relation to those assets, whether they have an identifiable issuer or not, then what's the difference between that requirement and the white paper requirement? I think you've answered that. But then I want to go back to one thing that you mentioned, which is that presumably you would argue that assets without an identifiable issuer present a lower risk profile, and that this is part of the rationale for this interpretation when we're just looking at the recital before looking at the articles. That's an interesting argument, because it's also contingent, right? There's nothing necessarily preventing assets without an identifiable issuer to also be more risky. It is maybe more or less likely. But actually, that brings me to the other argument that was presented in our previous webinar, to say that to argue for white papers for these assets, and this one is a bit more sophisticated, and it went about actually discussing what an asset without an identifiable issuer is. Because the risk that our previous speaker also was seeing was, well, if all I need to do to be out of scope of MiCA is to hide myself, to be pseudonymous, I can just hide my identity and then I can do whatever I want, because I will not be covered by this regulation. So if we interpret very literally that a crypto asset without an identifiable issuer is out of scope, then we create an incentive for issuers to hide their identity, which would defeat this lower risk profile that you identify, will make it higher risk profile. And that wouldn't make sense. So the alternative interpretation was a historical argument for how the term identifiable issuer originally in historical terms was very much related to the asset being decentralized. So an asset does not need a white paper if it's decentralized. It's not really whether the issuer is pseudonymous or not. And this matters, of course, because we're not just talking about Bitcoin here. We're talking about Bitcoin and similar assets. So we need to know what a similar asset is. What do you think?
I do have an answer for that. And the answer to that is that we cannot cherry pick certain terms in MiCA to the exclusion of the rest of the regulation, because Recital 20 gives us the answer to that. And the answer to it is that an issuer is a person who has control over creation of crypto assets, regardless of whether they're anonymous, pseudonymous, or up until that stage, not identifiable. If you take a look at, for instance, the smart contract for the token, and you can see that someone would still have privileged access, that there's still an address which has privileged access to to certain parameters concerning the token issuance itself, then it would be very difficult to argue that there is no issuer. It's clear there's an issuer, and just because the issuer hasn't been identified doesn't mean that the crypto asset will fall outside the scope of MiCA altogether. So in order to truly meet the test of a crypto asset without an identifiable issuer, we should also keep in mind as well that just 2 recitals prior to recital 22, there's a statement that says that if a person has control over the issuance of a crypto asset, they will be deemed to be the issuer itself. And unfortunately, it would be too convenient of an exit for someone to just hide and not make themselves known, and therefore the crypto asset would be excluded from MiCA scope. I would venture to argue that would not be within the spirit of the law itself. And again, as much as I like finding loopholes, so to speak, or exemptions, I don't think that's sound enough of a loophole, to use that term, to warrant a crypto asset to be excluded from MiCA scope.
That's very interesting. And if we can get a slide back on screen, we'll see here recital 20, which is what Jonathan was referring to, right? An issuer needs to have control over the creation of crypto assets. And I think, Jonathan, if I interpret you correctly, it looks like you have just made a distinction between an identifiable issuer and an identified issuer, right? The fact that an issuer has not been identified doesn't mean it's not identifiable. Am I on the right track here? Or what would you say about?
You are definitely on the right track, Juan. And I'll make reference as well to another point that you made earlier on as well. We have to, as much as possible, and as difficult as it may be sometimes, we have to try and understand the mindset and the intention of the legislator when the law was drafted. Again, here I'm just going to express my opinion. Once again, I am not the legislator. But I would venture to say that when specifically recital 22 was drafted, the term non-identifiable issuer was mostly meant for Bitcoin. Now, after, of course, the very first draft of MiCA was dreamt of and perhaps sent for internal discussions, up to this day, I'm sure there's a lot of other crypto assets which currently do not have an identifiable issuer. But once again, the law has to be read in its totality. And I would say that recital 20 is perhaps more important in terms of determining whether there's an issuer or otherwise, and which exemptions may apply or otherwise, than recital 22 and the phrase non-identifiable issuer.
Right. All right. So very interesting. You're making me think a lot. All right. Then how about we start diving into the articles, right? You're making the case that the recitals are important, but not that important, right? We should be looking at the articles most of all. Would you care to elaborate again why this distinction, why we should be looking at the article? What is the difference in legal nature before and after?
The articles are considered to be the law. The recitals are not considered as law. So whenever making any legal arguments, be it in a legal opinion, be it in front of a court of law, one should first and foremost rely on the articles themselves. They may substantiate their arguments by making reference to the recitals to somehow coincide their argument with the intention of the legislator, but ultimately one should never rely solely on the recitals themselves to present a legal argument, just because they're not the law.
Perfect, super clear. I had seen the argument that, well, if the regulator would have wanted to say that non-identifiable issuer and decentralized are the same term, then the regulator would have used the term decentralized issuer, right? It's sort of one of the tools we have in legal interpretation. But I guess the argument that it received last time was, well, yeah, that's one tool among others, but the others is investigating also what the legislator had in mind. So it's also interesting to see you don't just make that one argument that if the regulator had wanted to say decentralized, they would have said so. but also there's supporting arguments in looking at the spirit of the law and what the regulator had in mind back in then. Okay, but then let's dive into the articles themselves, and we can get the slide on screen again. There are some exemptions for in MiCA, mostly in Article 4. Would you care to tell us why they matter and what relevance they bear in this discussion about Recital 22?
Certainly. So Article 4 covers offers to the public of crypto assets that fall under Title 2 of MiCA. And right off the bat, under Article 4, Sub-Article 1, there is the requirement that if a person is making an offer to the public of a crypto asset in the union, which are three words that are sometimes omitted from legal arguments. So if there's an offer to the public of a crypto asset in the EU or the EEA, then a white paper has to be duly drafted, notified, and published in accordance with the requirements under Article 4 and the rest of Title 2. Interestingly, the legislator then affords us two exemptions, or two categories of exemptions rather. We have partial exemptions under Article 4 Sub-Article 2 and full exemptions under Sub-Article 3. Why are they partial and full? Article 4 Sub-Article 2, so the one that we have on the screen right now, exempts the offeror from drawing up, notifying, and publishing a MiCA compliant white paper if the offer to the public has less than 150 natural or legal persons, or is addressed to less than 150 natural or legal persons, if the total consideration for the offer to the public is less than 1 million, and if the crypto asset can only be held by qualified investors. What does this mean? It means that although a MiCA compliant white paper is not required to be published, the rest of Title 2 still applies to the offeror. So certain obligations on offerors, the requirement to keep the crypto assets collected if it's a time-barred offer with a licensed CASP still stands, and pretty much every other provision under Title 2 applies to the offeror in question. Title 3 is a bit more interesting because Title 3 fully exempts offerors from having to comply with Title 2 of MiCA. And let's keep in mind that Title 2 of MiCA is also comprised of Article 5, which covers admission to trading.
Right.
So if we read Article 4 Sub-Article 3 in its totality, we can surmise that not only isn't there a requirement to publish a MiCA compliant white paper, but pretty much everything else in Title 2 does not apply either to the offeror or, by extension, to the crypto asset itself. So if the crypto asset is offered for free, truly for free, as we can see in the proviso to Article 4 Article 3, if it is automatically created as a reward for the maintenance of a blockchain, if it is concerning a utility token that provides an access to a good or service that exists or is in operation, and ultimately under Sub-Article D, if the crypto asset can only be used in exchange for goods or services within a limited network, then if any one or more potentially of those exemptions under Article 4 Sub-Article 3 is met, then there's a full exemption from compliance with Title 2 of MiCA. And once again, for clarity's sake, that includes as well an exemption from having to comply with Article 5.
So let me actually pause on that and actually double click on it, because I also want our listeners to actually realize the extent of this exemption, right? We're saying that you are exempt from the entire title if the conditions or screen are met, on screen are met. This is a very, very broad brush. First of all, John, was this deliberate? Was this meant to be like this? Did they mean to write title, do you think?
Once again, not in the mind of the legislator, especially back then. But I would venture to think that this was deliberate. Here, we are dealing with crypto assets that are either not being offered to the public in return for any consideration whatsoever. Therefore, again, the regulatory obligations on part of the offeror should automatically be diminished if they're not receiving any consideration whatsoever for the distribution of the token. The second one concerns crypto assets that are automatically created in order to sustain the operation of a blockchain network, be it
But
proof
actually,
of work, proof of stake. Yes?
yeah, let me stop you in that, because that one, I mean, aren't a lot of crypto assets created as a reward for validation of transactions? Wouldn't this mean that any crypto that has staking rewards coming from inflationary supply creation be out of scope? Or should we interpret this Article 4.3b as exclusively created as a reward for the maintenance?
I would venture to opt for the second one. That the crypto asset has to be exclusively automatically created, and that if there was, again, pick your term, an ICO, a TGE,
Right.
which first created a certain a certain amount of crypto assets, potentially allocated to certain parties. And then afterwards, the blockchain network was launched, and then the crypto assets started being automatically created, so to speak. Or again, more units, to be correct, started being automatically created. That is more of a gray area. My own personal opinion is that if the initial TGE or ICO, whatever it was launched after the applicability of MiCA, then it would constitute an offer to the public that would potentially fall within scope of Title II. If, however, and I think we'll be covering this point later on, the ICO took place before the applicability of MiCA, and the automatic creation of further units of the token started taking place before the applicability of MiCA, then potentially that particular crypto asset would qualify for this exemption under sub-article B of Article 4.3. Again, one cannot apply, I would say, a uniform interpretation to this because ultimately crypto assets are created in differing ways, and distributions are quite different from one blockchain network to another, or from one crypto asset to another. But yes, if there was a previous offering, one would have to be more careful because potentially this exemption will not apply.
Right. I mean, you're right that we will be getting onto the 2024-2025 milestone in a few moments. But I think I agree with you. It would need to be exclusive. Otherwise, MiCA would be creating like a broad exemption for inflationary assets. You would just need to introduce a bit of inflation to be exempt from MiCA. And I definitely don't think that would be a reasonable interpretation. But before we go on to also Article 143, which is what you were referring to, there is another paragraph right after this one in Article 4, which says that the exemptions listed in paragraphs 2 and 3 do not apply if there's if they make the say make known an intention to seek admission to trading. What do you think of that? Like, how does that change? How does that factor in what you just mentioned?
In this particular case, I mean, I would say it's a bit linked to the point that we were making earlier on, that if there's, say, an ICO which takes place, and then shortly afterwards, a blockchain network is launched, a permissionless one, where further units of the token are automatically created as a means of reward. Let's say that the person who organized the ICO, let's use that term, subsequently or even beforehand, state their intention publicly that the token will be available on trading platforms operating in the EU. And that is where this Article 4 comes in, where essentially it's been drafted in order to ensure that the exemptions afforded under paragraphs 2 and 3 are not abused of, so to speak, and that there is somehow still a relevant party involved which will go ahead and try and have the token listed on trading platforms in the EU and ultimately stands to derive significant benefits from the distribution of the token, including its admission to trading. Once again, we have to read the law in its totality. And I would venture to think that the intention of the legislator is to bring within scope persons who are exercising an appreciable amount of degree over the token, over its distribution, over its availability for trading, versus those crypto assets where there isn't one single particular party exercising material control over the overall ecosystem, in which case that particular token, that particular crypto asset should remain outside the scope of Title II, potentially outside the scope of other titles as well.
Right. I want to draw attention to what you're saying, right? You are, this is what you mean by reading the law in its totality. All of these exemptions and the exemptions to the exceptions to the exemption are all following a common narrative of material control or not. That's what I'm hearing right now.
Correct. And just to perhaps, and one last point on Article 4, sub-Article 4.
Yeah.
Let's use a silly example, perhaps. Let's say, and again, this is a stretch of the imagination, that the issuer of Bitcoin, being Satoshi Nakamoto, should also be regarded as the offeror of Bitcoin. Granted. Article 4 sub-Article 3 exempts Satoshi because it's being offered, automatically created as a means of reward. However, a person comes along, an identifiable person, holding themselves out to be acting on behalf of the offeror, on behalf of Satoshi, and says, well, Bitcoin is now going to be admitted to trading on exchange X, which is licensed under MiCA. Does that mean that the exemption no longer applies?
Right.
I think it's very hard to say that the exemption doesn't apply if we take such a literal interpretation of sub-Article 4.
So what makes it hard for the exception to the exemption to apply? Is it that somebody there's no material connection between this other person and Satoshi Nakamoto, or there's no demonstrable connection? Would that be the reason?
Rather that it's difficult perhaps to demonstrate, or rather not difficult. One would have to prove that the other person is truly acting on the offeror's behalf. Mm-hmm. Otherwise, any claim would automatically bring perhaps the offeror, who might not even have any knowledge of MiCA itself, within its scope. And ultimately as well, once again, the spirit of the law itself. For certain crypto assets, let's use the term decentralized crypto assets like Bitcoin, can we really and truly apply the sub-Article 4 in relation to Bitcoin itself? If someone seeks its admission to trading, should we then all of a sudden require a white paper for Bitcoin? Again, this is not the only text of the law itself. It's almost 200 pages long, and read in its totality, I would say that no white paper is required for Bitcoin, especially if we look at other provisions, which I hope we'll be looking at shortly.
Right. Well, in that case, let me, and thank you very much for that explanation. Let me jump to Article 143, which has a transitional regime. And usually our attention is devoted here to paragraph 2, but as we may see, maybe we need to pay attention to more than one paragraph over here. This has relevance to our conversation, because obviously if Bitcoin requires a white paper, if the other rival interpretation that we had presented at the beginning of this webinar is correct, then crypto asset operators of trading platforms will need to be working on Bitcoin white papers promptly, whereas if it's not needed at all, it is just not needed at all. And this article presents a transitional regime where if an asset was already admitted to trading by 2024, well, almost all of 2024, then you get a few years of a grace period to actually require a Bitcoin MiCA white paper, but then you would need it on 2028, basically. Whereas in the other interpretation, you don't need it after the 31st of December 2027 at all. So that barrier does not apply to us. So what's your take on this?
Certainly. So incidentally, I will start with subarticle 1 first, because it will also answer one of the questions tendered to us by the audience, which is, what is your opinion on the status of Ethereum under this paragraph? Presumably the previous paragraphs that we were discussing. Article 143 subarticle 1 states that Title 2 shall not apply to offers to the public of crypto assets that ended before 30 December 2024. Why Title 2? Because Articles 4 to 15 are precisely the articles that comprise Title 2. So in the case of the Ethereum ICO, which was concluded long before the applicability of MiCA, then in that particular case, that particular offer to the public is not within scope of MiCA, because MiCA wasn't even imagined when the Ethereum ICO took place. And since Ether is automatically being created as a reward and has so been created after MiCA's applicability, in my opinion, it would be able to avail of the exemption under Article 4 subarticle 3, meaning that Ethereum falls outside the scope of Title 2 and likewise does not require a MiCA compliant white paper. Now, in the interest of time, I'll jump straight away to Article 143 subarticle 2, because this is a point of crucial importance. First of all, I often like to vent my frustration at times that MiCA could have been drafted in a better manner. And I think Article 143 subarticle 2 is a clear example of this. Why? Because it starts off by saying that there is a derogation from Title 2, that this particular subarticle derogates from Title 2. But then, under subarticle B, there is the phrase, in the cases required by this regulation. So are we going to ignore Title 2, or are we going to take into consideration the cases required by this regulation for MiCA compliant white paper to be published, which incidentally, in that same subarticle, we're making reference to Articles 6, 8, and 9, and 12, all of which form part of Title 2. So which one should we be going for in terms of interpretation? Should we truly derogate from Title 2? Or should we take into consideration Title 2, specifically the cases where a white paper is required to be published?
So let me put a pin on that just to make sure our audience is clear on exactly the options here. There's a priori, there's two potentially plausible interpretations of which cases are covered by subarticle B over here, right? So operators of trading platforms by the 31st of December of 2027, they will need to ensure that a white paper is drawn up in the cases required by this regulation. And there is where we have two options. In the cases required by this regulation, inclusive of the derogation of Title II, or in the cases required by this regulation, exclusive from the derogation of Title II. So could this have been written in a better manner? I understand possibly yes. Do you have a preference on what should be the correct reading here?
So I would again go for the interpretation that we should be taking into consideration the law in its totality. And I'm happy to provide more, let's say, substantive arguments as to why that interpretation should apply. In the cases required by this regulation, as a phrase appears multiple times throughout the text of the law itself. It appears in Article 5, subarticle 2, which governs admission to trading on the own initiative of the trading platform itself. And before, again, perhaps the other camp, which might opt for the prior interpretation, says, well, Article 143 sub-Article 2 is preempting us from applying Title 2.
Yeah.
Well, I have some bad news for such persons in such camp, because Article 76 sub-Article 1, which covers operating rules of trading platforms, likewise states that if a white paper is not published in the cases required by the regulation, again, that all-important phrase, then the white paper should not be admitted to trading. What is the inverse interpretation to that? That if a white paper was not required in the cases required by this regulation, then no white paper, no MiCA-compliant white paper is required for admission to trading. And if I may just use another minute to also potentially cover another argument that I've seen.
So actually, before we do that, let me invite the audience. We are a bit running out of time. If there's any questions that you had other than the question we got on Ethereum, now is the moment to send it, because we'll be covering that. Jonathan, I was prepared for this webinar with slides on every article. I was not expecting Article 76, so I don't have one on that, and this is why you have a reputation for having memorized MiCA. But yeah, please go ahead.
So incidentally, then, as again, some other articles I've memorized. Actually, there's one I haven't memorized, which I'll come to shortly. Article 66 of Article 3, which covers general obligations of crypto as service providers, states that CASPs offering certain platforms, offering certain services, including the operation of a trading platform, must provide a hyperlink to any crypto asset white paper. Now, where the legislator wants to tell us something similar to MiCA-compliant white papers, it always states it, where it states a white paper has been drafted in compliance with Article 6, a white paper has been drafted in compliance with Article 16 for ARTs. This is the only instance where the legislator says any crypto asset white paper. So my interpretation is that if crypto asset is exempted from a MiCA-compliant white paper, and there is a white paper available, then a hyperlink should be provided to that white paper, regardless of whether it's MiCA compliant or not. Mm-hmm. On the other point, and this is where I'm not sure about my memory, I think it's Article 66 sub-Article 5, which relates to the environmental disclosures. Now, CASPs, no matter what services they are providing, should provide a disclosure pertaining to certain environmental metrics on the consensus mechanism utilized by the crypto asset in question. However, that same text of the law states that if such information is available in the white paper, then it should be retrieved from that white paper. If it's not available in that white paper, it can be retrieved from other sources. And I know that, again, there's plenty of other sources out there covering environmental metrics for certain popular consensus mechanisms, such as proof of work or proof of stake.
I have to look at it right now. Does it say that you should retrieve it from the white paper, or that you can retrieve it from the white paper? It says, it says that you may retrieve it from the white paper.
You may. So you could retrieve it from the white paper. If it's not available in the white paper, you can retrieve it from any other source.
Right. I mean, and this goes back to the thread, the common thread that you've been giving us through this entire webinar, which is that MiCA needs to be read in its totality, right? So formulations that come up in MiCA need also be read always in the same way. So in the cases required by this regulation is a formulation that would typically have the same meaning throughout the regulation. The case of white papers, though, is a very, very interesting now, because I guess I could make the case that white paper by definition is a MiCA white paper, or what do we call this? But you're right, it's not a white paper required by Article 4, a white paper required by Article 5, and so on. So that's a very interesting question that we're going to have to leave for the audience. And speaking of audience, there's one question that is coming right now. Okay, we had a question on the status of Ethereum, which has already been answered. We're also getting a question about the developments in Hungary. I'm not sure if you can comment on such specific developments.
I don't think it's relevant for today's topic, unfortunately, and I think I've already expressed my my opinion on the matter in a separate group. I would like to stick to today's topic if possible.
Yeah, I think I agree with that. We should probably be sticking to it. So as we actually have covered the questions that we've received from the chat. Jonathan, I would like to ask, is there any other remark that you'd like to make before we wrap up, or something that you want to draw attention to? Maybe, I don't know, I've also heard about this falling knife theory, or is there anything else you'd like to mention?
No, I mean, the only concluding comment is that, again, there seems to be this current practice that some trading platforms are requiring MiCA compliant white papers, no matter the crypto asset in question, no matter if certain exemptions apply. That's a bit of a dangerous practice to undertake, because as you are aware, as the audience is aware, there are, let's say, certain concerns that, for instance, ESMA is overreaching its remit by applying the law or interpreting the law in a manner which extends beyond the very text of the law itself. It would be very hard for the industry to argue that and try to potentially arrive to a solution where ESMA does not interpret the law in its manner, where at the same time we are over-interpreting the law. We are applying requirements where no requirements apply, but then asking ESMA not to do the same thing. So again, we have to take everything into consideration. We have to ultimately apply the law as it is. If we overstep the boundary of the law, again, that can bring with it unintended consequences for all parties involved.
So if you are a part of a crypto asset project, you're engaging with a crypto asset trading platform for the listing of a token. This asset listing team sometimes has a list of boxes to tick, and one of the boxes could be, give me a white paper. Would your advice be actually check if the white paper is needed and let them know that maybe it's not needed if an exemption applies, push back on these requirements?
I would say that this could be the, let's say, best option if the trading platform was the one who approached the token team, where, again, doesn't really make sense that a trading platform approaches a token team and then tells them, oh, we want to list you. Can you prepare me a white paper for us, please? I mean, again, even rationally, it doesn't make much sense.
Yeah, so
if, on the other hand, if it's a token team which is approaching a trading platform, therefore it is seeking admission to trading, again, that is a bit more of a tricky situation, because although one might rely on certain exemptions, then ultimately, again, what is the spirit of the law? If there is a party which is actively trying to seek admission to trading, they were somehow involved in the original offering of the token, which might potentially have taken place years ago, but they're still involved in active efforts to have the token listed, and more liquidity is available. It becomes a bit more of a nuanced situation, and again, each case has to be considered on its own merits.
I think that's a very nuanced observation, very appropriate for all the rich landscape of observations that you make, Jonathan. So I want to take the opportunity to thank you for sharing all of this with our audience. It's being made available in LinkedIn, in YouTube. It's really a great opportunity to be able to discuss these things with you. I'm sorry we didn't have probably more time to cover them. We would love to have you back some other time. And of course, if there's other topics that the listeners would want to see us cover another occasion, please let us know. We want to tackle the difficult questions in MiCA, and we have had the golden opportunity of getting the thoughts of Jonathan, who is really, really into the weeds of everything. So thank you very much for everything.
Thanks for the invitation. I loved our discussion, and certainly love to join for future discussions.
Well, with that, we're wrapping up. Thank you, everybody, for attending as well. And we'll be seeing you next time. I know you're very interested in discussing maybe DORA or some other topics. So stay tuned for more developments.